petition and appeal in the matter of Manaquel Company Limited and Manaquel of Lambeth.
Miller.
Thank you, my lord. I appear on behalf of the appellant in this matter, and my own friend Mr. Ham appears on behalf of the respondent. Both of us appeared below in the Upper Tribunal and the First-Tier Tribunal, albeit I was led at those times. May I first check if the court has received an updated core bundle, 122 pages long, hopefully with reference skeleton arguments.
Yes.
There's a supplemental bundle as well of 573 pages.
Can't speak for the number of pages, but we have it.
I'm grateful. And then there should also be an authorities bundle with the relevant extracts marked in the margin of 259 pages. There have been two applications listed before the meat of the appeal is heard, and those are both to do with the supplemental bundle. The first is for the appellant to be able to rely on the supplemental bundle as it was then filed, and the second is to have permission to rely on the new supplemental bundle, which is, as I say, 573 pages long. I understand that attempts were made to agree the contents with the respondent's representatives, but their position was that apart from the improvement notice, nothing in there was relevant to the appeal, and therefore none of it should be before your lordships and your ladyship. I don't believe any alternative index was provided. For my part, I do propose to refer to quite a lot of the supplemental bundle. It's referenced in my skeleton argument, and for those reasons, and given nothing in there is new to the respondent or to the court, I would submit that the appellant be given permission to rely on that bundle. There's a very short submissions on that issue. I'm not sure if my learned friend wishes to oppose that application, but certainly without being able to see.
Are we going to argue about the supplemental bundle?
Well, I think our view was that the supplemental bundle, which is very large, the vast majority of documents do not go to the core issue in this case, which is whether Hussein applies to improvement notices.
Yeah.
I was slightly mollified in my position when I saw that Mr. Miller's had referred in his skeleton argument when he came to code up his skeleton with pages he was referring, but that's in the early part of his skeleton, and it really is background material rather than I think the material that the court needs in order to determine the grounds. That was our view, but I'm not opposed to the idea of the court referring to one or, I mean, the notice I understand by the rules of court, the actual improvement notice could not be put in the main bundle, which I didn't initially.
What are we going to do about it now? I mean, are you...
No, so if you need to refer to the notice or wish to refer to parts of the supplementary, but the vast majority of that bundle is all to do with the work that was done
Yes.
after the notice was issued.
Yes. Well, it's just that we'll allow the bundle in, and if anything is referred to which for some reason shouldn't be, then we can argue about it then.
So be it.
Thank you. I propose to introduce the case, go through parts of the Housing Act 2004, because by my calculation, this appeal is only the third time this part of that act has reached the Court of Appeal, and then I'll move on to Ground 1 and Ground 2, and in that process I hope to be able to also save my learned friend some time. To begin with, the court could be forgiven for thinking that this appeal is about a substantive improvement notice, but it's actually about Rule 13 costs under the First-Tier Tribunal rules. The matters in this appeal are of great significance to local authorities and the recipients of improvement notices and other notices that can be served under Part 1 of the Housing Act 2004. It's of particular concern to the appellant and the respondent, because I'm informed by my instructing solicitor sitting behind me that the respondent has served a further 112 improvement notices on the appellant, of which 79 have been appealed to the First-Tier Tribunal. As far as the background facts are concerned, on the 20th of October 2021, the respondent served an improvement notice on the appellant, and the reference for that is supplemental bundle page 4. It followed a variety of inspections undertaken earlier in that year, predominantly in April and May, as set out in the witness statement of Miss Charlotte Ward. and it recorded a Category 1 hazard of excess cold and hot surfaces and materials, and a Category 2 hazard of excess heat. It's a relatively lengthy document. The meat of the appeal, and by appeal I mean what the FTT heard, set out in Schedule 2 on page 18, and there's a lengthy list of works to be carried out to windows, to the plant room, to substations, networks, dwellings, and so on and so forth. There is also, as required by the Housing Act 2004, a statement of reasons for why this action was taken. It's at page 22. The time limit for appealing an improvement notice is 21 days, and on the 5th of November 2021, so a little over 2 weeks later, the appellant appealed to the First-Tier Tribunal. At that stage, the appellant did not have the Housing Health and Safety Rating System, I'm going to abbreviate that to HHSRS, or we will be here for all of today, calculations, or any notes from the respondent. The grounds of the application included that the appellant was expecting a decision on planning permission, on which it had spent about £1 million at that point, which would mean that everything in the notice would be the subject of some work or other anyway, and would have the effect of reducing or removing any hazards that were present on the estate. It was also alleged that not enough time had been given to enable consultation under Section 20 of the Landlord and Tenant Act 1985. Directions were duly given by the First-Tier Tribunal on the 8th of December 2021, and I do propose to refer to them briefly. They begin at page 65 of the supplemental bundle by Tribunal Judge Hamilton Ferry. And as is quite common with First-Tier Tribunal directions, it attempts to define the issues, which are on page 66 at paragraph 4. And they include the issues the tribunal will need to consider include: do hazards exist, and if so, what category? Should the council take enforcement action, and if so, what enforcement action is appropriate? There's also a bullet point over the page about whether a prohibition order may be more appropriate if possession of these flats needed to be obtained for the works to be carried out. The directions went on to order disclosure of the HHSRS calculations, that's at paragraph 6, and that was done, but only in relation to excess cold and excess heat, not hot surfaces and materials. And then in the bundling directions, it's page 69, under the section how the respondent, the council, should prepare for the hearing. It states the bundle should include any report by the officer responsible for the notice and employed by the respondent, and that was never provided. The parties then filed statements of case, the respondent going first. That's also in the supplemental bundle. Very briefly at page 74, paragraph 18. The respondent noted the appellant's proposal that it would be doing certain works anyway, or has done certain works, and respectfully reserved its position on these specified works until a further reinspection of property can be carried out. And that was also not done. The appellant filed a reply, paragraph 2 of which criticised the improvement notice and disputed the existence of hazards. I don't need to go through that in detail, but for your lordships and your ladyships notes, that's on page 75 of the supplemental bundle. Due to various delays that weren't the fault of either party, the final hearing actually took place on the 2nd and 3rd of October 2023, so almost 2 years after those directions. The morning of the 2nd of October 2023 was occupied by a site inspection in which the judge, that's Judge Corn, and the professional member, Mr. Miller, who had a background in environmental surveys, myself, my leader at the time, Nicholas Isaac KC, and my learned friend all went to the site, walked around a few select flats, and were accompanied with actually a number of tenants as well, as it happens. both parties used evidence. For the respondent, their main witness was Charlotte Ward, who was at the time the team leader for the private sector housing enforcement team in public protection, assurance and regulatory services. That's her title. And her witness statement, again, just for notes later, is at page 470 of the supplemental bundle. The First-Tier Tribunal's decision records that Mr. Isaac KC put it to Miss Ward that the date of the assessment of an improvement notice was the date of the hearing, and that she had not provided any evidence of a recent re-inspection. The appellant, for its part, adduced the evidence of Mr. Brian Kane, which exhibited a tracker of works. And this was the subject also of an updated witness statement. That tracker, I think it's the most recent version, is at page 314 and is probably very tiny type on a physical copy. It's fair, I think, to say that the respondent focused its energy on the excess cold hazard and on the windows. In closing submissions, the respondent sought to vary the improvement notice and essentially request an adjournment of the decision to enable it to re-inspect Dorchester Court, come up with some proposals, and that's set out, anonymously, this finding is actually set out in the costs decision at paragraph 14, which can be found on page 116 of the core bundle. Paragraph 14 also records that a conference was held. This is incidentally reciting Mullane Friends submissions, written submissions, in respect of the Rule 13 costs application, that the respondent held a conference to consider what works had been done and what concessions could properly be made at the hearing.
But just to get our bearings at the moment,
Yes.
this background, which obviously we have read the judgments, so
Yes.
Is this going to ground 2? Because ground 1 is a pure point of law, isn't it?
Yes, my lord, this does go to ground 2. So what I'll be submitting in summary with ground 2 is that both parties, and indeed the First-Tier Tribunal, were proceeding on the assumption that the date of assessment was the date of the hearing, and that it was for the respondent to justify the improvement notice and the works that were going thereto. And so I recite this simply to give the background that it's a genuine active decision made by the respondent, not merely something passive that didn't occur to it.
Is that in dispute?
I don't believe it is, but it's a point in favour of ground 2. But I can move very quickly on from
Well,
there.
you must take your own course, but it just seems to me that going through a lot of detailed material in relation to matters which aren't relevant on ground 1 is a point of law, and which aren't in dispute on point 2 may not be the best use of your time.
Understood, my
Court's
lord.
time.
In that case, I'll be very brief. The only other matter I'd really like the court to go to is page 350 of the supplemental bundle. The reason I'm setting out this background is because ultimately this is a question about Rule 13 costs. And the reason why all of this background is important is because there's a list at paragraph 4 of the application made by the appellant for Rule 13 costs at page 350 of the supplemental bundle of various criticisms it had in support of the argument that the respondent acted unreasonably. Martin Roger KC in the Upper Tribunal decided that because of Hussain, in essence, this list is substantially reduced.
So where's the list? I'm sorry?
It's page 350 of the supplemental bundle,
Yes.
paragraph 4.
350.
350.
That,
It's not page 350 either.
no,
Mine.
not mine either.
I take it that means that the updated supplemental bundle hasn't reached the court.
Yeah.
Well, I can look.
When was it sent?
It was sent in back in March, if memory serves. That was when the updated core bundle was sent. I'll try and find the old bundle and see if I can find reference in that.
What is the document we're looking for?
It is an Order 1 application form, made by the appellant. Trying to find the date. Dated the 14th of December 2023.
That could be a
Three
page.
6-1,
Yes, 360.
On 3/6.
360. Well, it looks like it's an application to request for case management or other interim orders. That's dated the 14th December 23.
Yes, that sounds correct.
Right. Well,
361, you've got paragraph 4 and a list.
which goes over onto page 363.
From A to H. Those are the points that's the list of points you're referring to.
For reasons I'm not aware of, it may be our bundles are 11 pages out, so I'll make a note of that, and I apologise that we're working off different bundles.
I'm looking at the updated supplementary bundle online, and that also, page 360 is not this document.
Oh.
That's the cost decision.
Should be 350. I think you said it was 350.
Yes, 350 on mine.
350,
electronic
sorry.
version.
Yes, sorry, yes, I've got it now.
I'll be spending some time in the enforcement guidance, operating guidance later. That's also in the supplemental bundle. I'm therefore hoping the pages will align, but we'll do my best. In essence, the reason I'm going through this is because if the appeal is allowed on ground 1 or ground 2, that has the effect of rendering these 8 reasons, all of them, good again, whereas before Hussain had rendered some of them bad. And the reason why Judge Roger did not remit it to the First-Tier Tribunal, didn't decide the matter himself, was because the effect of Hussain was to essentially dilute this list. Melenford and I have spoken about how to handle the matter were the appeal to be allowed, because Willow Court has 3 stages when it comes to Rule 13 costs, and all of this only goes to the first stage. There's still a second stage as to whether an order should be made, and a third stage as to quantum. And it may well be there'll need to be submissions in writing after that point, because it's not necessarily a given. Obviously, I'm not going to make Melenford submissions for him, but it's not a given that if you allow the appeal on ground 1 or ground 2, that a Rule 13 costs order will be made.
Does ground 2 have a separate life if you're wrong on ground 1?
Yes, my lady. So ground 2 assumes that Hussain applies. It essentially tries to argue that the Upper Tribunal erred by approaching the cost decision on the basis that it could attack the substantive decision.
But
The
if
First-Tier
you win on-
Tribunals,
you win on ground 1 or ground 2, or indeed both, you're just left in the position that of the First-Tier Tribunal's decision, which you appealed. But really, what the succeeding on the appeal just simply means that it wasn't dealt with appropriately in the Upper Tribunal.
the Upper Tribunal found that the First-Tier Tribunal's decision was flawed also because it didn't answer the ultimate question. So it didn't answer the question as to whether there was an explanation for the conduct of the respondent. So the First-Tier Tribunal's decision is flawed anyway, whether or not Hussain it's flawed. And in those circumstances, I would invite your lordship and your ladyship to remake the decision yourselves. Naturally, if you're not with me on that, then the answer might be to remit.
Yes.
But these are all consequential matters. I'll move on now then to some of the statutory background. I do intend, of course with the court's permission, to address you on various parts of the Housing Act 2004 and the Housing Health and Safety Rating System. As I said, I've only been able to find one other case where this was actually considered by the Court of Appeal, and that's Wood and Kingston, which I'll make submissions about later. But given its unfamiliarity, in my submission it'd be useful to go through the Act, and I can make certain points as to ground 1 as I'm going through anyway. So for that purpose, I'd like to refer the court to the authorities bundle, beginning at page 18. Which is section 1 of the Housing Act 2004. it explains that it provides a new system of assessing the condition of residential premises and for how that system ought to be enforced. And it does so by replacing an existing test in the Housing Act 1985, which was on the basis of fitness for human habitation, with a new system referring to Category 1 and Category 2 hazards and the HHSRS. And fitness for human habitation, of course, has now been brought back into private law by the Homes Fitness for Human Habitation Act 2018. It's an implied term now in most short tenancies. Subsection 3 lists the kinds of enforcement action which will use the new system. And at C, it refers to the existing kinds of enforcement action dealt with in Chapter 4, demolition orders and slum clearance declarations. And those are to be found in the Housing Act 1985, not the Housing Act 2004, although amendments were made by this Act. As for the meaning of Category 1 and Category 2 hazards, those are set out in Section 2 on page 20. They are both hazards of a prescribed description falling in a prescribed band as a result of achieving a prescribed method for calculating the seriousness of hazards of that description, a numerical score in relation to a prescribed amount. There's a definition of hazard as well. Regulations and guidance were issued when this section came into force. So the HHSRS, which I'll come to later, has the same effective date. If memory serves, it's the 6th of April 2006. My learned friend says in his skeleton argument that the HHSRS is an evidential tool. And I wish to submit that it isn't an evidential tool. In fact, the only way of calculating whether hazards are Category 1 and Category 2, and only by having that calculation, is the local authority required to take action or given a power to take action. So it's better thought of as a kind of gateway. There's no duty or power until this kind of assessment is carried out and the calculation has been worked through. Section 3 requires local authorities to keep housing conditions in their area under review. And then Section 4 sets out how inspections should be undertaken. Section 4 is on page 23. And subsection 4 refers to inspections being carried out in accordance with regulations made by the appropriate national authority. And then we get to the question of, assume that an inspection's happened and one comes out with a score, what happens then? Well, Section 5 imposes a duty to take enforcement action. And at subsection 2, there's a list of what the local authority can do. There's quite a long list for these Category 1 hazards. They include improvement notices, but also demolition orders under the Housing Act 1985. And if there's more than one course of action, the authority has to choose the most appropriate of those available to them. That's subsection 4. For a Category 2 hazard, Section 7 applies, that's page 26. And it confers power on local authority to take particular kinds of action. Those are listed. They also include power to make a demolition order under the 1985 Act as well. Section 8 requires a statement of reasons. Subsection 2, the authority must prepare a statement of the reasons for their decision to take the relevant action. Those reasons must include the reasons why the authority decides to take the relevant action rather than any other kind or kinds of enforcement action available to them under the provisions in sections 5.2 and 7.2. Subsection 9 is the provision which introduces guidance. And this is very important. There are 3 items of guidance, and there's one that's very specific to fire safety, which isn't relevant for today's purposes, but there's also the operating guidance and the enforcement guidance, both published in February 2006 by the Office of the Deputy Prime Minister, to which I'll refer your Lordships and your Ladyship later. And subsection 2 of section 9 requires the local authority, says they must have regard to any guidance for the time being given under this section. As for the various courses of action available to local authority, chapter 2, page 29 of the authorities bundle, begins with section 11, which is an improvement notice for a category 1 hazard. There's also section 12, which is improvement notice for category 2 hazards. And in either case, they're defined as a notice requiring the person on whom it is served to take such remedial action in respect of the hazard concerned as is specified in the notice in accordance with subsection 3 to 5 and section 13. Section 14 of the Act allows for improvement notice to be suspended either for a time or on the occurrence of an event. And section 15, which is important, and my friend and I will no doubt be trading submissions on this, page 32 of the authorities bundle, discusses when an improvement notice becomes operative. And the answer is 21 days if not appealed, or if it is appealed, then essentially when the appeal is resolved. Subsection 6 states, if no appeal against an improvement notice is made under that part of that schedule within the period for appealing against it, the notice is final and conclusive as to matters which could have been raised on an appeal. I will submit in due course that's very important when considering the course of action available to a recipient of a notice. And given, as I'll submit later, there's not actually any limits on what can be raised in an appeal, this provision will render quite a lot of matters final and conclusive. Section 16 requires local authorities to revoke improvement notices if they're satisfied its requirements have been complied with, and they may revoke in special circumstances for category 1 hazards and if they consider appropriate for category 2 hazards. And there's also provision in subsection 4A which allows variation with agreement. And both of these decisions are also appealable, but the right to appeal is located in Schedule 1. And Schedule 1 is given effect by Section 18. And before going to Schedule 1, it's worth noting in passing that Section 30 makes failure to comply with an improvement notice a criminal offence. Section 31 gives effect to Schedule 3, which in essence allows the local authority to take enforcement action itself, enter onto the property, carry out the works, bill the recipient. And Section 37 provides that improvement notice will be a local land charge. Not in the bundle, but Section 40 of the Housing and Planning Act 2016 allows rent repayment orders to be made as well, where a landlord has failed to comply with an improvement notice. So I'll move on now to Schedule 1. Which contains the provisions and disputes. That begins at page 67. Paragraph 10 is the first provision that's particularly apposite to this case. That's page 71, as it sets out the right of a recipient of an improvement notice to appeal. And it's very general. So there's two specific grounds of appeal in paragraphs 11 and 12, but otherwise there's no feta here. 11 concerns an appeal where someone else is either the proper recipient themselves or the proper recipient jointly with the actual recipient. 12, however, is very important for this case in my submission. It provides that a person may appeal on the basis that one of the courses of action mentioned in subsection 2, so including prohibition orders, hazard awareness notices, etc., is the best course of action in relation to the hazard in respect of which the notice was served. And then 2 lists the courses of action. It's worth noting those courses of action in paragraph 12.2, they're not actually the same as the full list available to the local authority. 13 then sets out the right of appeal in relation to a revocation or variation or refusal to do those things. 14 sets out the time limit, 21 days for appeals against improvement notices as served and 28 days for appeals concerning variation or revocation. And then paragraph 15, which is very, very similar to the appeal provision that was in Hussain to do with licenses, Schedule 5, paragraph 34 of the Act. states that the appeal is to be what by way of rehearing, but may be determined having regard to matters of which the authority were unaware.
You say it's very similar. Is it different in any way, any material way?
15.2 is identical. The other provisions are slightly different. So 15.3 refers to the tribunal quashing a notice. The word in Schedule 5, paragraph 34 is reverse for licence decisions. I don't suggest incidentally that has any difference on construction.
But the decision, a lady's reasoning in
Yes.
saying was directed entirely at the words which are here repeated in 15.2.
Yes, I completely recognise that, and I will come on to Hussein in a moment. I do, of course, recognise that I am up against a rebuttable assumption when it comes to the construction of this provision. And I recognise that Hussein decided that these words meant that the date of assessment was the date of the decision, and that there were also a great deal of deference to be given to the local authority as decision maker. I do, of course, appreciate that Milady was gave the lead judgment in Hussein as well. But I'll come on to submissions as to why, on the appellant's case, that decision can't be read across to improvement notices and other notices under Part 1 of the Housing Act 2004. And for one, there are actually two special provisions that's set out in subparagraph 4 there, in connection with grounds of appeal set out in paragraphs 11 and 12. So 12 was to do with there being another course of action available, and 17, just over the page, states that when deciding whether one of the courses of action mentioned in paragraph 12.2 is the best course of action in relation to a particular hazard, the tribunal must have regard to any guidance given to the local housing authority under section 9. Now, to submit the fact that it's the tribunal having regard, and not the tribunal, as it were, reviewing the decision of the local authority, which gives a much greater weight to the tribunal's own assessment of the situation. And then further, if an appeal on this basis is allowed, subparagraph 4 provides that the tribunal, if requested to do so by the appellant or the local housing authority, include in its decision a finding to that effect and identifying the course of action concerned. And that course of action is the course of action mentioned in 3b, which is the best course of action in relation to the hazard. That completes my review of the Housing Act 2004. The next important piece of legislation is the Housing Health and Safety System England Regulations 2005, and that's at page 90 of the authorities bundle. I can summarise my point with this, which is that the judgments that a local authority makes when it comes to assessing whether there's a hazard, and if there is a hazard, what to do in relation to it, is a much more scientific matter than deciding whether a person is fit and proper to hold a property licence. And I'll make good that submission, especially when I come on to the guidance a bit later. So these regulations came into force on the 6th of April 2006. That's the same time as Part 1 of the Housing Act 2004. And it contains those prescribed matters for Category 1 and Category 2 hazards. And what they do in summary is they convert subjective probabilities into a number, and then they use those numbers to come up with a total. Those totals are filtered through into a band, and what band you're in determines what category the hazard is, and also how serious it is within that particular band. Let's begin with Regulation 5, that's page 91. Provides that an inspector must have regard to any guidance for the time being given under section 9 of the Act. Must inspect any residential premises with a view to preparing an accurate record of their state and condition, and prepare and keep such a record in written or electronic form. So the obvious reason why one would do this is because if an appeal is brought, you actually have the reasoning behind the local authority's decision and their assessment of the hazard. There's an expectation, in other words, that this particular part of their judgment will be looked at and possibly scrutinised in detail. Regulation 6 sets out the seriousness of hazards. It's quite a long provision, but it is worth spending some time with this. So it sets out a formula. First, the inspector inspects property, and they determine that a hazard with a lowercase h exists. And they then consider it appropriate to calculate the seriousness of that hazard. In Regulation 2, the inspector assesses the likelihood during the period of 12 months beginning with the date of the assessment, so it's forward-looking, of a relevant occupier, and that's defined later. For excess cold, for example, that's someone aged 65 or over, of a relevant occupier suffering harm as a result of the hazard. And that produces something called a representative scale point of range, which in most cases is roughly the midpoint of a range of probabilities. And these numbers, 1 in 4,200, 1 in 2.5, whatever, that's the likelihood of a relevant occupier suffering any harm at all. And it does go up quite high. So over the page 92, it goes up as high as more likely than 1 in 5. And that actually produces a representative scale point of range of basically 100%. And then, of course, it goes down to much smaller numbers. So let's take this case as an example. If the inspector thought that there was a 1 in 50 chance that the relevant occupier will suffer harm, the RSPR gives you a number of 56. And then subparagraph 3 requires the inspector to assess which of the 4 classes of harm the relevant occupier is most likely to suffer. They're set out in Schedule 2. That's not in the bundle, but in summary, Class 1 harm is death or other extreme harm. Class 2 harm is severe harm, and examples are given, such as losing a hand or a foot, serious burns, loss of consciousness for days. 3 is serious harm, including hypertension, sleep disturbance, or loss of a finger. And 4 is moderate harm, including occasional severe discomfort or a slight concussion. There's then a formula for working out the relative chance of each type of harm. And that will also produce certain percentages. So, again, to take an example from this case, if the inspector considers there's a 26 to 38% chance of extreme harm, including death, you end up with a figure of 31.6%. And it is worth pausing at this moment to note that these numbers can actually give you the chance that a relevant occupier suffers a particular harm in the next 12 months. So in this case, the respondent's calculation for excess cold gave an RSPR of 1 in 56 and an RSPPR of 31.6%. If you multiply them together, you get approximately 1 in 177 chance of relevant occupier dying or suffering from extreme harm from excess cold. I should say that is accurate to 3 decimal points. The actual sum is 79 over 14,000, but that's harder to visualize. Once you have those numbers, subparagraphs 5 and 6 set out a formula. It's worth looking at subparagraph 5 and how it weights the formula. So class 1 harm, that's 01, is weighted in the sum of 10,000. You compare that with 1,000 for class 2 harm, 300 for class 3, and 10 for class 4. And in practice, that means that if there is any kind of class 1 harm, it's going to make up the bulk of any calculation. It just will, mathematically speaking. And finally, Regulation 6 provides for the bands. So there's bands A, B, and C, they're category 1, and D downwards is category 2. I'll now move briefly on to guidance before reaching my submissions on grounds 1 and 2. The guidance is in the supplemental bundle. I appreciate that we're working from different pagination. What I have is the enforcement guidance at page 92. If that's not right, I'm hoping that we're out by the same number of pages so I can do some quick arithmetic in my head.
I think it starts at 91.
Yes, that's the front page. It's published by the Office of the Deputy Prime Minister in February 2006, and it's given to assist local authorities in deciding what is the appropriate enforcement action under Section 5 and how to exercise discretionary powers under Section 7. The operating guidance is at page 129. I cross my fingers. Also published by the Office of the Deputy Prime Minister in February 2006. Chapter 1 of this is very useful for setting out the backgrounds to the HHSRS. So that's page 135. Now, draw the court's attention to 102. The HHSRS is founded on the logical evaluation of both the likelihood of an occurrence that could cause harm and the probable severity of the outcomes of such an occurrence. It relies on the informed professional judgments of both of these to provide a simple means of representing the severity of any dangers present in the dwelling. And in 104, the HHSRS is evidence-based, supported by extensive reviews of the literature and by detailed analyses of statistical data on the impact of housing conditions on health. And there's a series of hazard profiles at the back, which set out what those are. It's plainly far more scientific, has a much more rigorous objective basis than assessing whether somebody is fit and proper to hold a property licence. And as for how old this is, because I appreciate that may be a question as to how much weight to give to this document, it's set out at page 176. And this is Annex D, which includes the profiles of various hazards. It's the third bullet point from the bottom, in the paragraph beginning, preventive measures and the ideal. And it refers to the optimum current at the time of preparation of this guidance, January 2004, so it predates the passage of the 2004 Act. I'll revisit this in my substantive submissions. So unless there's any item of background, I do appreciate, of course, the court has read a great deal of this material, and I propose to move to ground 1 at this stage.
Yes, please.
So ground 1 is that the Upper Tribunal was wrong to find that appeals against improvement notices are to be assessed at the date of service of the notice, rather than the date of the appeal, and also wrong to decide that a First-Tier Tribunal should afford special deference to a local authority's decision to serve a notice. I also need to begin with Hussein. I can't avoid beginning with Hussein. And of course, I have to concede that Hussein is not ideal for the case that the appellant is running, because it produces at the very least a rebuttable presumption. Hussein was a licensing appeal. I perhaps don't need to go through the facts of it, given how central it was, and my lady gave the lead decision in that. But it was explicitly considered in that case whether someone is fit and proper should be assessed at the date of the decision of the local authority or at the date of the appeal, and then what deference ought to be given to the local authority when judging fitness and propriety. The test for fitness and propriety was set out in Section 89 of the 2004 Act, and there were certain matters to which the local authority had to have regard, so criminal convictions for fraud and dishonesty, and the contravention of landlord and tenant law were two examples given in Hussein. And what to make of that evidence is plainly a value judgment for the local authority. As I stated, Schedule 5, paragraph 34.2 is identical to Schedule 1, paragraph 15.2. The Court of Appeal decided that it was not a rehearing in the fullest sense of the word, but the various pointers in its construction to the determination date being the decision, not the hearing, and that generally speaking, events occurring after the decision being of limited relevance. Ground 2 concerns the deference to be given to a local authority, and it is worth going to page 194 of the authorities bundle quickly on that. Paragraph 77. It's the third line right at the end, sentence beginning with but. Even then, if the decision involves the exercise of discretion or judgment by another person or body, the appellate tribunal will not interfere with the original decision, unless, having afforded it with great respect or considerable weight, is satisfied that the decision was wrong. As Judge Roger KC noted below, there's a presumption that where the same words are used in the same Act of Parliament, they have the same meanings. It is, however, a rebuttable presumption, and an extract from Bellion and Bailey is in the authorities bundle, which sets out that proposition. It's section 21.3, page 247. I don't believe it to be contentious law. Whilst the bottom of page 248 sets out that there's no absolute rule that one word cannot have two different meanings within the same section or subsection. True, it will only rarely occur, but the ultimate question is what the Parliament intends. To determine that, it is necessary to look at the Act as a whole. And so that's where my submissions will be directed. So the Act as a whole, it will be how the Act has been interpreted in subsequent decisions, and a comparison between housing, health and safety, and licensing to show that Parliament had different intention when it came to passing Schedule 1, paragraph 15(2). I'm going to broadly follow the structure in my skeleton argument, which is to say, dealing with the differences between licensing and housing, health and safety. Then I'm going to move on to the legislative context and a bit of the history behind the provisions, and finally, existing case law. Although I appreciate only one of the cases actually binds the Court of Appeal, and that's Wood. The others are persuasive, all being upper tribunal authorities. It is worth considering what the connection is between licensing and the housing, health and safety rating system. They appear in different parts of the 2004 Act. Licence conditions may include provisions as to the facilities that might be made available to an occupier, to fire alarms being in place and so on. But section 55(5) of the 2004 Act requires local authority, I'm quoting here, to satisfy themselves as soon as is reasonably practicable that there are no Part 1 functions that ought to be exercised by them in relation to the premises in respect of which such applications are made. Aside from that, the housing, health and safety rating system isn't incorporated into licensing or vice versa. And the enforcement guidance actually has a section on this. So going back to the supplemental bundle briefly at page 120. Part 6 of this guidance describes the link with licensing. And 6.1, the very last sentence, says, an assessment under HHSRS is not part of the licensing procedure. It goes on to say that where a person satisfies an authority that they are fit and proper for a licence, the local authority should not delay the grant of a licence pending consideration of its duties or powers, under Part 1. Also quotes section 64 67(4) of the 2004 Act states, as regards the relationship between...
Where are we now?
It's maybe part of the Housing Act 2004 that's not in the bundle. I'm just going to double check that. Yes, so this is Housing Act 2004, section 67, subsection 4. States, as regards the relationship between the authority's power to impose conditions under this section and functions exercisable by them under or for the purposes of Part 1, A, the authority must proceed on the basis that, in general, they should seek to identify, remove, or reduce Category 1 or Category 2 hazards in the house by the exercise of Part 1 functions and not by means of licence conditions. So to the extent one might want to make the submission that licensing and housing, health and safety are part of a a broader package of schemes, and therefore one can very easily read across Schedule 5, paragraph 34 into Schedule 1, paragraph 15. I would submit that isn't correct. I submit it, in fact, it makes sense that there's a difference. The housing health and safety rating system requires a person with expertise, such as surveying, to inspect and calculate hazards. The same person is not necessarily going to have expertise in borough-wide licensing schemes or in the assessment of the fitness and propriety of applicants to manage properties. It may well be that certain local housing authorities have different departments dealing with these things. As seen in the extracts of Hussain, which are sidelined, it's important consideration when considering the deference to be given to the primary decision maker, the value judgments they have to exercise. And of course, I accept there are some value judgments that have to be made under the housing health and safety rating system, but I submit they're much more limited than licensing, and they are much more susceptible to analysis, and in particular scientific analysis.
Where you place this risk, these risk factors, when these very large brackets of some quite unlikely risks, there's got to be an element of judgment in that, hasn't there?
Yes, I accept there is judgment in that, yes. It's worth going to the operating guidance on this. Page 143. Of the supplemental bundle. In paragraph 302, states there'll be 2 judgments from the inspector. They're an assessment of the likelihood over the next 12 months of an occurrence that could result in harm to a member of the vulnerable group, that's the relevant occupier, and a range of potential outcomes from such a recurrence.
Both of those require considerable exercise of judgment based on expertise and experience, don't you?
Yes, I wouldn't resist that.
And presumably you'd accept that the tribunal would have to have considerable deference to the views of the inspector in that regard.
I wouldn't go on to make that concession, my lord. And the reason is that there's a great deal more backing these assessments in terms of what is prescribed, the factors to which an inspector has to have consideration, and also the fact that this does produce at the end of the day a percentage, which is of course testable, that while there is some deference, I don't accept that it's the deference that one might give to a housing authority when granting or refusing a licence. I say there's some deference, but it's not on the Hussain side of the spectrum when it comes to rehearings.
Well, that's just your assertion, isn't it?
Well, I'm going to refer the court to various parts of this guidance in terms of its background, also to various other features which are capable of, as it were, objective testing.
What this all goes to is the question of whether in one single act, 2 identical wordings in relation to the process of appeal should be read in completely different ways.
Yes, my lord, that is the case.
It just doesn't seem to me to even start to justify. When Lady Justice Andrews' reasoning in Hussain, nothing to do with any such matters. They were just simply interpreting the words on their face and what they must mean. It seems to me it's difficult to, not sparing her blushes, but difficult to see any flaw in that reasoning at all that would not apply equally to the wording in this case.
Well, I don't intend to attack Hussain, not least because it's not open to me, it binds the Court of Appeal. My submission on Hussain is that it is particular to licensing appeals.
It isn't, it's just addressing the words. If Lady Justice Andrews had been addressing the words in this case, she would have said exactly the same thing, wouldn't she?
Well, I wouldn't want to...
Because in relation to the words, I mean, what you've got to persuade us is there's something in the background that means that the words mean something different to Lady Justice Andrews' interpretation of them in Hussain.
Yes, I appreciate I have that. There is that rebuttable presumption to get over. I've taken Your Lordship to the extract from Benyon where it says it's a rebuttable presumption and one must have regard to the Act as a whole. And the Act, of course, incorporates reference to guidance, and the HHSRS regulations as well set out a much different exercise from one that pertains to licensing.
Forgive me, I'm just completely failing to understand how any of this means that you would read the words differently, particularly when you interpret them based upon clear meaning of words, as we know has been authoritatively and bindingly established in relation to the wording in another schedule.
Well, I can skip. I can go to my submissions on that now, if that was this, and come back to the guidance. I do submit the guidance is relevant because it determines the nature of the judgments that are being made.
But all we're talking about is the timing, but the date as at which the appeal has to be considered. And you may say, well, these are different matters being considered, but at the end of the day, it's a very simple question. And there's nothing, I mean, you're not saying that you can't consider these matters as at the date of the notice.
Pardon me, I don't quite follow the last.
You're not saying that this doesn't work in some way, are you? You're not saying it can't mean this.
I will be submitting that if one assesses at the date of the decision, it can produce some absurd results, yes. It could result in the First-Tier Tribunal confirming notices where matters have been significantly overtaken. It could require the First-Tier Tribunal to disregard the preferences of the actual occupier and force upon the landlord's scheme of work.
The same in relation to licensing, couldn't it? There could have been events which have happened which meant a licensee was or wasn't fit when they had been at the time.
Indeed, but someone who doesn't get granted a licence simply has to wait and make another application. Whereas when it comes to improvement notices, they're forced to carry out sometimes quite substantial works. This language, in terms of the appeal, also applies to prohibition orders. And if one reads this across to the remaining parts of the 1985 Act, so demolition orders, if it applies to that as well, you could theoretically get a First-Tier Tribunal ordering the demolition of a property when actually there's nothing wrong with it anymore.
In that case, you'd apply to vary, wouldn't you, or revoke?
Yeah.
The difficulty with that is that Section 15.6 makes anything to do with anything that could have been raised on initial appeal conclusive and final. And so I do appreciate that one of the arguments that Judge Roger identified below is that if they're, let's say, the recipient wishes to take a different scheme of works, they could invite the local housing authority to vary the notice. That's true, but Wood and Kingston, which is a Court of Appeal decision, Lord Justice Lewison said in that an appeal against an improvement notice is partly against the work specified in the notice, and plainly if one can appeal at the date of the notice and say that a different scheme of works is intended, if one doesn't appeal at that point, then the notice is conclusive. And I'd submit that you can't then rely on that when it comes to appealing a variation. It's already been determined. So the proper course of action upon receiving an improvement notice and the recipient stating there's a better scheme of works is to appeal then and there to vary, not to request a variation and appeal the refusal to vary that notice. And this is why I say in my skeleton argument that if one does go down this route, it leads to appeals being on a confused basis.
But on your basis, it's a completely movable feast.
I do, of course, have to accept that. But I'd submit that that's a common sense approach to housing standards enforcement, where the whole idea behind it is to make sure that houses are, well, essentially fit to be lived in by the relevant occupiers. If one were to assess at the date of the notice, it could result in, as I said, rather absurd results, confirming things that are no longer necessary.
It also means that the local authority's got to keep on inspecting, hasn't it?
Yes, indeed. But there are certain circumstances in which the local authority has to inspect anyway. So it has to re-inspect. It may well wish to re-inspect before revocation. If it suspends a notice, the guidance sets out that it ought to re-inspect periodically anyway. So re-inspecting is not fatal at all to my construction.
Actually, there are downsides from on either approach, but at the end of the day, one's left with the words which, on their face, indicate that the decision has to be taken on the basis of the matters known at the time, save for matters of which the local authority was unaware. They can only be unaware of matters which existed at the time. They can't be unaware of matters which only happen in the future, can they?
Given the decision is in some way predictive, it says what is likely to happen in the next 12 months, as in the decision affects the future, and attempts to set out probabilities for what may happen in the future. And that is literally part of the definition of a Category 1, Category 2 hazard. I'd submit that in that context, these words would include matters of which the local authority were unaware, would include matters of fact happening later. So I'll give an example, which I suppose is a hybrid example. Suppose that a recipient of a notice says, I accept there are hazards, but I have an alternative scheme of works that is far cheaper, less disruptive to my occupier, and it will have the effect of eliminating the hazards. And the local authority doesn't suspend, revoke, vary the notice. Now suppose the recipient appeals that, and in, let's say, a year, carries out that alternative scheme of works. It is surely relevant to the question of as to whether that improvement should be varied, to see if the scheme of works proposed which have been implemented have had any effect on the hazards. Now one can locate that in the past and say, for example, the local authority were unaware of the propensity, and we use the language of the propensity of these works to reduce the hazard. There are gymnastics to refer it to the original point of the decision, but in my submission it's far easier, far less tortured, to simply allow that later evidence to stand and be part of the factual matrix which the First-Tier Tribunal is assessing. To take an extreme example, I put in my skeleton argument that what if there's a 50% chance of harm? My learned friend has taken me to task on that in his skeleton argument and said, well, conveniently, that's the balance of probabilities. I have already referred to the fact that the representative scale point of range allows assessments up to a certainty, 100%. It allows 50%, allows 33%, 16%, and then downwards. In appropriate circumstances, you could test this and come up with an objective answer that the local authority is wrong. The obvious example is if I appreciate it's going to be extremely rare in practice that anyone would say there's a certainty of someone suffering a hazard. But if it were, and no one did, the local authority is, in my submission, simply wrong. And you can only assess that at the end of the 12 months. And given the whole point of the housing health and safety rating system is to assess the likelihood in the future of something happening, I'd submit that plainly what happens in the future is relevant to an assessment on appeal. I do have submissions on the 1980.
Sometimes said in various contexts that that the worst way of judging a decision is by its outcome.
Right.
Well, equally, I would submit that the best guide to what would happen is what does happen.
No, it isn't. No, it isn't. That is a logical fallacy with respect.
Ignores the whole concept of probability, doesn't it?
To take that example of a very high hazard assessment, one where it's more likely than not that someone suffers a particular category of harm. If nobody does, and the level is sufficiently high. And to take the example as well of the...
That doesn't mean that the probability didn't exist. That's the point. Whenever one's dealing with anything on an evaluation of probabilities, there will always be a category of cases where it doesn't happen.
Yes.
Because you're always evaluating whether it's more likely than not that it will. And so the fact that it doesn't mean that the evaluation of the probability is wrong at the time at which it is made. It can't do.
My submission on that is one can, in certain circumstances, measure the likelihood of, so again, to use an extreme example, 99%. Let's say there's a 1% chance of something not happening in a given year.
And it doesn't.
And it doesn't, yes. Well, one can use probability to come up with an actual number. So
But it still doesn't mean that the 99% assessment was wrong. That just sort of flies in the face of the whole purpose of the probability assessment. You can only evaluate whether or not somebody was right or wrong to say that it was more likely than not, or 99% right, at the time they make that assessment. You can't turn around and say, oh, well, it didn't actually eventuate, so the probability was wrong. I'm afraid that's just nonsense.
I'm just going to work out some numbers.
Numbers won't assist you, I'm afraid, Mr. Miller, because this is a fundamental mathematical point.
Yes, but there are statistical models which would enable you to assess a notice in this way.
Can we just go back to the fundamental question
Yes.
here? It seems to me that we have one appeal scheme which in this act which has been authoritatively determined its meaning and you're not challenging it, and we have an identically worded scheme elsewhere in the act. It seems to me that, and you say there's a rebuttable presumption, it seems to me that it's a very strong presumption, and that one would need something pretty clear and dramatic to demonstrate that the legislature meant something different when it used exactly the same formula. And it seems to me what you're identifying is a series of factors which might go one way or the other and might have influenced the legislature one way or the other in reaching a decision. But at the end of the day, we know what they did provide, and they provided the same scheme as they provided in relation to licensing. And it doesn't seem to me you're coming close to identifying anything which would rebut this presumption.
In that case, I'll move on to make submissions on the remaining parts of the 1985 Act, because there is a different test in that, and it's part of the same scheme, in summary. So, as I discussed earlier, the 2004 Act set up a new scheme of enforcing housing standards, but certain remedies remain in the 1985 Act. An important one goes to the authorities bundle, is section 265 of the Housing Act 1985. This is a demolition order. It's available for category 1 and category 2 hazards.
So which page is this? I'm sorry.
Page 4 of the authorities bundle.
Thank you.
And there's a right of appeal against that. The up-to-date version, as now in effect, is at page 10 of the authorities bundle. And the right of appeal against order, section 2693, on appeal the tribunal may make such order either confirming or quashing or varying the order as it thinks fit. So as it thinks fit is language that goes, it's additional language to that that's in the Housing Act 2004. And there doesn't appear to be any further guidance as to how those appeals ought to be conducted.
So forgive me, how does that interrelate then? I'm not sure I'm understanding the point.
So one ground of appeal against an improvement notice. So first of all, demolition orders are a course of action available to local authority when identifying a category 1 or category 2 hazard.
Yes.
It's part of the same set of procedures for enforcing housing safety.
Yes.
And one would expect that appeals against demolition orders and against improvement notices, prohibition orders, and the rest that are in the Housing Act 2004 would be the same.
Why?
Well, because they're inherently part of the same set of remedies.
But the other argument is it shows that if the legislature wishes to provide for the tribunal to look at the matter as at the date it's dealing with it, it can so provide.
And a demolition order is a very different thing because once it's done, it's permanent. You can't rebuild the house. So it's a pretty dramatic event. And given that it's permanent and it's dramatic, one can well see that Parliament might say, well, you've got to look at the situation as it stands on the ground at the moment and see whether or not it's worth that sort of draconian action being taken.
I'd submit in relation to that when compared with licences, improvement notices, prohibition orders, the like, are also significantly more weighty matters. I would ask if one is going to package improvement notice appeals into another set of appeals, if one was to choose between licensing and demolition orders is the preferable category in which to put it because it's part of the same set of
If you're looking at the two, forgive me, legislature chose the licensing formula, not the demolition formula. And doesn't that
And
go
the
against?
demolition formula has been taken out of the Licensing Act and remains separate under the 1985 Act.
So yes, there's a deletion in 3B, which was a result of a later act, but 3A I understand is original. The original is page 8. That reflects the court rather than the tribunal.
Yeah.
There is a further connection because section 269A, which is page 14, sets out a ground of appeal against a demolition order on the basis that other courses of action are preferable. Now, bear in mind that this is exactly the same provision as in the Housing Act 2004 for appeals against improvement notices. One can appeal improvement notice on the basis that it's the wrong course of action. One can, there's a different best course of action, and one can appeal a demolition order in exactly the same way. I submit that they're plainly extremely connected to one another.
Well, again, forgive me, but I understand that. But then doesn't that make the difference in wording all the more significant?
Well, this wording is in a way incorporated into the Housing Act 2004 by section 1, which refers to this course of action as being among the other course of action. In my submission, the fact that the appeal provision was 3A was largely unamended is, if anything, a hint to what Parliament intended when passing Schedule 1 to the 2004 Act. But there are other differences, which I can move on to. So going back to the 2004 Act for a moment. Schedule 1. Page 71. I've adverted to this when I was going through the Act earlier. Paragraph 12.1 allows, this is the same provision, but crucially it refers to what is the best course of action. Now I've emphasised is in my skeleton argument as being a present tense. My own friend says in response that the only reason the word is used here is because the right of appeal arises when you receive the notice. So the is contemporary with the notice itself and refers to the decision. Well, one has to read this with paragraph 17, page 74, which applies when the First-Tier Tribunal is actually assessing the appeal. 17.2. When deciding whether one of the courses of action mentioned in paragraph 12.2 is the best course of action in relation to a particular hazard, the tribunal must have regard to any guidance given to the local housing authority under section 9. So again, it's the authority having regard to the guidance. And then 3, subparagraph 4 applies where an appeal is allowed on this basis. B, the reason or one of the reasons for allowing the appeal is that one of the courses of action mentioned in paragraph 12.2 is the best course of action in relation to that hazard. Again, present tense. It doesn't say was the best course of action. It would have been very easy to have said was at the date the notice is served. And then 4, the tribunal must, if requested to do so by the appellant or the local housing authority, include in its decision a finding to that effect and identifying the course of action concerned. In my submission, it's completely useless for the first-tier tribunal to say, well, the improvement notice was wrong, you should have served a prohibition order 3 years ago. This provision is clearly attempting to give the local housing authority some kind of useful information. In my submission, that has to be present information. It serves nobody, the recipient, the occupier, or the local housing authority, to be told with hindsight what it could have done years ago. Instead, it's very useful for the tribunal to tell the authority what it can do now.
Well, presumably, just to pick up one aspect of this is, one suspects that these provisions don't have in mind that the appeal will be years after the decision. It's presumably assumed that it will be relatively soon after the decision.
I confess to not knowing the state of it was the court originally, or the tribunals in 2006. I was 11 years old at the time. But nowadays, at the very least, I think it can confidently be said it does take a year, at least, for these things to come around. And even then, even if it is only 6 months later, that's still the date of the appeal. I'm just going to find my place, if that's all right.
Yes, of course.
I've made submissions on the conclusivity point in section 15.6. I'll move on to existing case law then, which is strictly my third heading in my skeleton argument. And there are 3 cases I'd like to discuss. Only one of them, which is Wood, is binding at this level. That's at page 165 of the authorities bundle, decision by your colleagues, Lord Justice Patton, Lewison and Underhill, back in 2017. It's a bit of a confusing set of facts. In essence, the upstairs and downstairs neighbours were required to carry out works to both of their properties to ameliorate a fire hazard. And one of the issues in the appeal was whether the notice should properly have included alternative schemes of work and who the proper recipient was to carry out that work. The important bit for present purposes is on page 175, which is Lord Justice Lewison's judgment, in which he sets out the scope of appeals. Includes that the word quashed doesn't import a public law test. Then goes on to say, it's about a third of the way down that paragraph, sentence beginning with thirdly. An appeal to the tribunal is, or at least includes, an appeal on the merits of the works required by the notice. On such an appeal, the tribunal has the power to vary the notice. That power is in itself inconsistent with the application of public law test. And then goes on to say, in my judgment, it is not necessary for the tribunal to be satisfied that the inclusion of a particular scheme of works was irrational and therefore unlawful before it can exercise the power to vary. The grounds of appeal against improved notice are unlimited, and a dissatisfied recipient of such a notice is entitled to appeal on the grounds, say, that there exists a cheaper and equally effective alternative to the works required by the improvement notice. Then the next paragraph talks about the tribunal itself being satisfied that the best way forward is a different course of action. It concludes by saying that does not mean either notice was unlawful, it merely means that having heard the evidence, a tribunal is satisfied that there is a better way forward. There's 2 points here. The first is the emphasis on the tribunal being satisfied and the fact that the tribunal can consider the works required by the improvement notice. Puts this close to the, one could consider, spectrum of rehearings, complete on one side, saying it's probably not completely on the other side, but close to it. In my submission, this would bring one close to the complete rehearing side. the fact that the First-Tier Tribunal can assess the works for itself, rather than simply deferring to the local authority, deciding whether the works are in some way wrong, gives a greater role to the tribunal. It also adds to the absurdity I mentioned earlier, which is there's really no utility in varying a notice to include pointless and out-of-date works.
What Justice Lewison is considering here is whether this is effectively an appeal process or is it some sort of public law challenge. I'm not sure that he's going anywhere near as far as you're suggesting. I mean, he refers to the fact the grounds of appeal are unlimited, entitled to appeal on the ground, that is, at the time he appeals, that there's a cheaper and equally effective alternative. So that's the ground of appeal. And then if the tribunal is satisfied, that is, after hearing that appeal, it may vary the notice to give effect to his decision. What does one get out of that?
Simply that there's a greater emphasis on what the tribunal is thinking fit. I would submit that Hussain wouldn't approach it in this way if applied to improvement
thinking fit
notices.
is it this way. It's satisfied on the evidence. Isn't it?
Yes, but one has to ask what kind of deference is it paying to the local authority as decision maker in this process?
Well, I don't think what Justice Lewison is addressing that.
No, of course not.
Well, thank you for showing it us. I'm not sure really. You say it's binding on us. I'm not sure that it binds us in any particular direction.
Well, to the extent, I would submit this is support for the proposition that the First-Tier Tribunal can itself, as it were, without regard to the local authority's material, assess the works in the notice and come up with an alternative scheme. And from that, I would submit that, again, to avoid absurdity and the First-Tier Tribunal confirming a notice or varying a notice to include works that were set out at the date of the decision rather than the date of the hearing, well, it would result in absurdity. One can test it by considering the situation where the appellant appeals on the basis that, so an approved notice sets out works A, and the recipient says, hold on, I prefer works B, and then later discovers that actually set of works C is better. It would be wrong in my submission to lock them into works B.
That's not what this judgment is addressing at all.
No, I appreciate it's not what the judgment is addressing, but in my submission it follows from the fact that the tribunal is entitled to consider the works that are set out, and as to whether the tribunal itself is satisfied, rather than whether the local authority was right to put set of works A in the notice. I do, of course, agree that the particular issue in this appeal hasn't come up in improvement notice appeals before. If it had done, then we wouldn't be here.
You're postulating that work C was not on the table at the time of the decision. For some reason has come out of the blue since.
Well, it's perfectly possible that that might be the case. I mean, one can think of an improvement notice served in 2016 saying, put this cladding on your building, and then discovering it's the same cladding used in Grenfell. Or you might say, there's a better way of heating your flat, and then heat pumps being invented and becoming commercially available. Technology does move on, and a lot of what's in the enforcement guidance has obviously moved on in terms of building regulations. If it later becomes desirable to carry out certain works for reason of cost, or because the technology didn't exist, in my submission it ought to be open to the tribunal to consider that.
But we're still in the realms of a decision, an appellate decision as to whether a decision taken by a person who has the authority to take that decision was wrong.
I would say,
And there is something somewhat bizarre about saying a decision taken by somebody is wrong in circumstances where you're relying on something that couldn't possibly have been taken into consideration at the time when the decision was made.
I'd submit that in this particular context, the phrase having regard to matters of which the local authority were unaware would be wide enough to contemplate that. But I'll move on to the remaining two cases, and these are both upper tribunal cases. The first is Oldford 2. which is at beginning page 97. And this was an excess cold hazard case with improvement notice. The First-Tier Tribunal's reasoning is set out in paragraph 3 on page 99, and it's rather light. But the explicit grounds of appeal, which are recorded at paragraph 35 on page 108, two issues. One is whether the First-Tier Tribunal was entitled to take into account the absence of complaint by the actual occupiers, who incidentally in this case were a great deal younger than the relevant occupiers, and whether they shouldn't have brought into their own perception of the time of the inspection as to how warm the property was, and also their knowledge and experience of similar premises. And the Upper Tribunal, this is the President's decision, held that the First-Tier Tribunal was entitled to take account of all of these three things. Paragraph 43, page 111. Addresses the views of the actual occupier. It said that back then it's the Residential Property Tribunal. Oh, pardon me, that might be the the forerunner to the First-Tier Tribunal could properly have regard to the views of the actual occupier, and as far as choosing what course of action was concerned, the views of the occupiers were manifestly material. As it happens, that's actually an application of the guidance. So I can take the court to it if it's useful, but the enforcement guidance at paragraph 415, page 106 of the supplemental bundle states that authorities should also take some account of the views of occupants. Also sets out paragraph 49 that the turnover of tenancies is a relevant factor. Now, I'd submit rhetorically, what's the benefit of not taking into account the views of the actual occupier at the date of the hearing? What if it's changed?
So forgive me, as a matter of law, what is this authority helping you with? I'm not sure I understand at the moment.
So the views of the actual occupier, as opposed to the relevant occupier for excess cold is someone aged 65 and above. The actual occupier in this case was a young family, if memory serves. And the President is saying that the views of the actual occupier can be a factor in terms of what the First-Tier Tribunal decides. My submission off the back of that, I appreciate this doesn't decide that in as many words.
It doesn't decide it at all. It decides that the views of the occupiers who were in occupation at the time of the decision was a material factor. You're trying to get something out of this authority which it doesn't decide.
I'm using this to submit that not having regard to the views of the actual occupier at the date of the hearing would be absurd.
But that's a submission rather than relying on this to
Yes, indeed.
as authority.
Pardon me, I hadn't intended to represent that this case had decided that proposition. I do apologise if I've misled
Really
anyone.
trying to understand what proposition it does stand for. I mean, if you're using it as an example or something, you say, I mean, I don't understand this authority is addressing the issue of what is or isn't, or what date the matter should be assessed. That they just did it. They just did that in this case, just as the First-Tier Tribunal looked at the date of the decision and the date of the appeal in the present case.
Yes, my lord. I'll move on to the remaining 2 points in this case then. I'll be careful to make sure, refer to what is submission and what is decision. There's also paragraph 44, which sets out that the First-Tier Tribunal was right to take into account the subjective feeling of ambient temperature when the tribunal inspected. Now, plainly, that's something that happens later than the date of the decision. It's also very subjective. The tribunal's walked around, maybe with a coat on, maybe not, thinking at the time of year how cold it is, how warm it is. I would submit that in terms of the deference to be given to local authority, one accepts this proposition that the subjective views of the members of the First-Tier Tribunal when walking around the estate are a relevant factor in what the First-Tier Tribunal decides, that is hardly having deference to the local authority's decision.
It's hardly not. It doesn't tell you one way or the other. It simply says that it's something you're entitled to take into account.
But by definition, it's later than the date of the decision.
Yes, but it's still... All it's saying is it's a relevant factor.
Yes, my lady. And then finally, the case decides that the First-Tier Tribunal...
Saying, sorry to interrupt you, but unless the point is that you say that the result of Hussein is that one can never take into account anything that occurs on a site inspection.
I would say, by reference to the fact that this is something that happens after the decision, Hussein would render such evidence problematic. And indeed, what Judge Roger said below was that ultimately it wasn't for the respondent local authority to justify its conclusions. If one starts with the proposition that into the mix goes an site inspection that happens long after the decision is made, and that what occurs to the tribunal's mind at the time is a relevant factor that comes into it, I would submit that one has strayed somewhat from giving the local authority deference in its decision, because plainly it can't have had regard to the temperature on a random day in the future, maybe on the first day of the trial, as it was in this case.
By logic, that submission would have to apply to an inspection which took place the day after the decision was made.
Well, yes, it would. I have to accept that.
Isn't there, as a matter of evidence, wouldn't it simply be said, well, look, this is the position on this particular day. We assume, unless somebody indicates to us a reason why, we assume that the position has continued from the date of the decision.
But maybe possible.
It's just a matter of evidence, isn't it? And
yes.
It may be said, well, no, that things have changed, but then that may not be said.
Yes.
It may be that the inspection goes into a room where the windows are still defective, just as they were defective when inspected by the local authority, and the members of the tribunal can feel how cold that room is because the windows are defective. Well, they're experiencing that later than the date of the decision, but the factors are the same as the date of decision.
But they may be experiencing it differently.
Well, of course.
So an inspector may go in and subjectively feel the temperature's cold. Another person may find it hot.
How this works out evidentially, and it seems to me none of this goes to the question of how you interpret the words of the relevant schedule.
I've made my submissions on that. I'm
sure you can point to many instances in different tribunal decisions where the tribunal appears to have taken into account matters subsequent to the decision.
In that case, I'll move on to the last one, and this is post Hussein as it happens, and that's in best view. So it came out relatively recently. Page 229 of the authorities bundle. Decision of Judge Elizabeth Cook and Mr. Mark Higgin. This concerned 15 prohibition orders on the hazard of overcrowding. There's a list of policies, etc., from paragraph 5 onwards as to what is appropriate when it comes to space requirements for dwellings. And Hussein is citing the decisions that happened. So paragraph 12 on page 232. The passage to which I would like to draw the court's attention begins on page 238 at paragraph 51. I appreciate this does not directly decide the matter, it's an Upper Tribunal decision as well, but it's what I would draw from it in terms of support is that it is possible to be more objectively critical of housing, health and safety rating matters than is with licensing, such that a more, as it were, objective approach, an approach which gives the FTT more powers, is appropriate. So the previous section talks about evidence and has a very useful overview, in fact, of how one comes up with a rating system number. There's record at paragraph 48 as to the appellant's argument about the likelihood of harm. So Miss Dickman is she's the inspector, and she responds at the end of that paragraph. She's asked that the idea that 1 in 180 people would suffer harm was not real, and her response was, "I just took it from the guidance." So the guidance has for each of the hazards, or for most of the hazards, it has a list of various properties of different ages and the average likelihood of harm and the average spread of harms. And that almost gives you a default for various properties. It also means that certain things objectively can't be a factor in favour of a hazard. So one example in this case was the single glazed windows. So single glazed windows were the norm at the date the estate was constructed. And so to the extent that one says there's a higher risk of harm because of single glazed windows, that's already baked into the averages, and the inspector would need to justify increasing the likelihood of harm or the class of harm. And this actually happens it's referenced in this case, as far as it happens with overcrowding. So 52 and 53.
Sorry to interrupt you, but this is a case in which the Upper Tribunal said that the underlying evidence that was relied on by the decision taker, the original decision taker, was flawed, seriously flawed, because no professional judgment was properly taken. It was an instinct rather than a proper assessment. And the FTT shouldn't therefore have relied on Miss Dickman, and they shouldn't have rejected the evidence of Mr. Rosner. And for that reason, the FTT went wrong, because this wasn't really a decision to which it had to pay particular deference, because it was a flawed decision. And therefore, applying ordinary standards and principles, the FTT got it wrong. But the one thing that one does get out of this decision is that they've applied Hussein. They have Judge Cook, who's an extremely experienced tribunal judge and would be probably the first person to say that this makes nonsense in this area, has actually applied it straight across into this area and said that's the guidance we're bound by.
Yes, I do appreciate she's said that she's applied Hussein here. My submission, if one looks at paragraph 53, the FTT was required to reach its own decision rather than reviewing the response decision. I suggest is a little wider than what Hussein would permit. And there's also an illustration here, simply that, unlike with the assessment of who is a fit and proper person, the numbers involved in housing, health and safety rating mean that one can look at it and immediately almost come to a kind of gut reaction. So let's take these numbers here. Middle of paragraph 52. Is unable to justify a figure of 1 in 180. We'll say why it wasn't 1 in 800, which is 10 times as likely as the national average, or 1 in 2004 times as likely. Means that her figure appears to be an instinct. I submit the one at least has to start with the actual assessment that the local authority has produced. And in the Upper Tribunal, Judge Rogers said that it was for the appellant to challenge it, but the appellant didn't have any notes that the respondent had produced during the report. It didn't even have one of the calculations for one of the hazards. One doesn't start with giving the local authority deference until the local authority has produced its report and set out why it reached the judgments it reached. That is inherently more involved in scientific process than with fitness and propriety.
You may be right about that we don't give deference to a judgment which on the face of it is flawed because it's not supported by any rational evidence and so on and so forth. But that doesn't mean to say that you wouldn't give it deference if it weren't flawed. I mean, the two are not mutually inconsistent, are they?
Well, not in that sense, but the prior question of how one assesses it's flawed is in my submission.
Okay.
Whether someone is a fit and proper person is very impressionistic. Whether a hazard reaches a certain band and what the likelihood of harm is something that is much more concrete, based on a great deal more evidence, where there's guidance telling the inspector what they can and can't take into consideration, what the national averages are, and how various factors may increase or decrease that hazard risk.
Just to spell it out, why does that, let's assume that's right, that deciding whether somebody's a fit and proper person is more of a value judgment, and there's a lot more meat on the bone when it comes to deciding whether there's a hazard and how best to deal with it. How does that help us on the construction point?
Well, when it comes to interpreting what a rehearing is, taking all of that into account, I would submit that it pushes the rehearing, again, if one thinks of it as a spectrum, closer to the complete rehearing point than to the other side. If one looks at what the underlying matter that's being heard is. Those are all the submissions I have on ground 1, unless I can be of further assistance, I'll move on to ground 2.
Yes,
I'm also
please.
conscious of time. So ground 2 is that the Upper Tribunal was wrong to approach the appeal on any other basis than the First-Tier Tribunal's substantive decision was correct. And this is a much briefer set of submissions.
This is on the assumption you failed on ground 1.
Indeed, yes.
If you win on ground 1, you don't need ground 2.
Yes, that's correct, my lord. And the point I'm seeking to make is that it wasn't open to the Deputy President to go behind the substantive decision of the First-Tier Tribunal when deciding the appeal from the cost decision. It's a substantive decision which does decide, or at the very least works off the assumption, that the date of the assessment is the date of the hearing, and doesn't have anything about giving the local authority deference as to its decision. That's final, unappealed and binding, as between the appellant and respondent. Neither can argue that it's wrong, and the cost decision is of course predicated on the substantive decision. So the appellant...
Is that an accurate characterisation of the substantive decision? Isn't the substantive decision simply that the improvement notice is quashed?
Well, I'd submit the reasons for why it's being quashed are also not up for grabs between the appellant and respondent.
This is a sort of issue of estoppel, is it? I mean,
I would articulate it perhaps as res judicata or an issue of estoppel, yes.
Well, they didn't decide the point though, did they? Because nobody argued it. It was just the parties.
My lord, it was argued. So there's a question put to Miss Ward that the date of the assessment is the date of the hearing. The directions that I took your lordship to earlier have it in the present tense as to whether hazards exist, and that's quite some time after the service of the notice. The respondent's reasoning for the actions it took was, as I say, they were deliberate. They had a conference. It was recorded in Mellon and Friends' written submissions, and decided what to do in terms of essentially abandoning hot surface materials and excess heat on the basis that certain work's been carried out, and only focusing on the windows, and then asking at the end of that hearing for an adjournment in order to adduce updated evidence as to the windows. All of those are very clear representations that everyone's understanding was that the date of assessment was the date of the hearing. And that,
I understand that, but that means it wasn't argued. The tribunal didn't decide that point, did they?
no, yes, I take that point. It wasn't like
Let's
one.
see, it could be a raised judicata or one issue. It may be that maybe you have some argument on the basis that the parties proceeded on a common assumption, on this hypothesis, a mistaken assumption. But the tribunal didn't reach this decision.
It didn't reach a decision as it didn't reach an explicit decision, having had the benefit of any argument that the date of assessment was the date of the hearing. No, I would have to concede that. But one only gets to its conclusion about quashing the notice if that is true. It would seem, certainly from what Judge Roger said below, that had it been decided on a different basis, had it been decided on the same basis, the substantive decision would have gone differently. I'd submit that one useful way of thinking about this is what would have happened in the First-Tier Tribunal if Judge Roger had remitted it. So it goes back to the same panel, it goes back to Judge Call, Mr. Miller, and they would then have to consider the items of allegedly unreasonable behaviour raised by the appellant. So one example is, just quoting from the main decision, the respondent is therefore in difficulty when it comes to evidencing the current position and the extent to which remedial action still needs to be taken. The same two judges, the judge and the professional member, would then have to decide that actually that's not right. In other words, they were wrong, and they'd approach the cost decision on a different basis from how they approached the substantive decision.
Yes, but looking at it very simplistically, if the position was that there were 8 grounds of criticism, for the sake of argument, 8 grounds of criticism, which might have justified making an adverse costs order, and the Upper Tribunal rightly says, well, 4 of those aren't available to you, but the other 4 are, it makes your position worse, not better in terms of cost, because you've got fewer grounds to rely on.
Well, my submission is that it would be very hard for a first-tier tribunal, having made the substantive decision, to then make a cost decision on a basis that conflicts with it. One was assessing the reasonableness of the behaviour of the respondent during the appeal. To a certain extent, in this particular context, one can take into account certain factors, such as the respondent being legally represented, which it was throughout the proceedings. My point is that if the respondent was going to approach the substantive appeal on the basis that further evidence were needed, on the basis that it needed to produce evidence as to the excess cold in windows to support a variation, that it was going to abandon hot surface materials and excess heat at the door of the tribunal, those matters are all unreasonable when one approaches the substantive decision on one basis. One would have to go quite a long way back in time to, let's put it this way, if the First-Tier Tribunal in the substantive decision had set down different directions, applied different principles, the whole case would have been very, very different from start to finish, not merely at the final decision stage. And it's against that final decision that the question of reasonableness of conduct needs to be decided in my submission. And what I was trying to communicate when going through the facts earlier is that this was a deliberate thing on the part of both parties. It's not as if the respondent was strung along by the appellant. There's plenty of material supporting the idea that the respondent also positively affirms that this is how it understood and proven notice appeals worked. And it is worth noting, to the extent that the appellant is wrong on ground 1, it is in fairly good company. It's in the company of the First-Tier Tribunal judge in this case. Part of my section in Skeleton Argument about there being a real point of public importance listed a number of First-Tier Tribunal decisions, some of which quoted Hussein, some didn't, where the same result obtained.
Where we get to though is that the First-Tier Tribunal, even looking at the matter as at the date it determined the appeal, determined that as a matter of its discretion that this did not cross the threshold for a cost order.
My lord, that's what it. Yes, that is what the First-Tier Tribunal decided. But Judge Roger identified a flaw in it's basically in paragraph 30 of its cost decision. Yeah. So the tribunal asked itself the question of whether the conduct of the respondent, having gone through a number of criticisms, admitted of a reasonable explanation. And Judge Roger says in his decision that that was unanswered. And that's why, incidentally, we get to the position where Judge Roger decides that the cost decision is wrong, but he will refuse the appeal anyway. And that decision in terms of whether the First-Tier Tribunal was right to carry on its approach in paragraph 30. So paragraph 30 essentially says that the respondent conducted, obviously on the assumptions of the substantive decision, conducted the proceedings incompetently, and never says anywhere that the respondent's conduct admitted of a reasonable explanation. I'd also submit there's something of a difficulty anyway conceptually, because obviously the respondent's conduct was on the basis that Hussein didn't apply in essence. It's very hard to assess it in a non-Hussein. Pardon me, it's very difficult to assess the response conduct in a world where Hussein applied to the substantive decision. But one still has a problem.
The what Mr. Rogers said was that his actual decision was that the FTT's cost decision was flawed because they didn't answer that question. Was it the paragraph 30 question? And you don't take issue with that. That's in your favour.
Indeed, that's correct. That's correct.
But he then goes on to say, well, that gives me three choices. I can decide it myself, I can remit it, or I can decide to take no further action. And he says, I'm not going to decide it myself because I don't think I've got the material to do so because you haven't given me all the material the FTT had. So I'm left between remitting it, which nobody really wants me to do, or not doing anything. And he decides, I'm not going to do anything. Now, I don't think you dispute, but he had that was a discretionary decision that was open to him.
Yes.
So what you're saying is that that decision was flawed. Why was that decision flawed? And I don't think because I think one of the reasons is that he says, well, everybody went off on the wrong basis. I think once one looks at Hussein, that wasn't the right base at all. So if one remits it, you'll have this unsatisfactory situation where quite a lot of the points that were taken weren't really valid points at all. And at the end of the day, I think enough is enough, and I'm going to draw a line here. And why is that not open to him?
Well, on the premises of ground 2, my submission is that Judge Roger wasn't entitled to go behind the back of the substantive decision the way that I've described. And that leaves the list of 8 factors completely in place, with his finding that the First-Tier Tribunal didn't answer the ultimate question. In those circumstances, the case for Rule 13 costs order is, in my submission, rather stronger. And if he had decided to appeal on that basis, he would have made an order of his own volition. So he says, so paragraph 80, page 62 of the core bundle. Judge Roger says, on any view, Manaquel's case for suggesting that Lambeth acted unreasonably is very much weaker than the case originally presented to the FTT. The FTT was not persuaded by the 8 grounds originally relied on. There must be a significant chance that the much smaller catalogue of errors which have survived contact with the same would also fail to persuade the same panel if the application were remitted to them for reconsideration. My submission is that if one goes back up to those 8, there's in fact a greater chance, not least because the First-Tier Tribunal decision didn't answer that ultimate question. Post-Willow Court, there was a Court of Appeal decision called Lee, which is in the authorities bundle, and GP Ilfracombe. And that, in essence, decided that one doesn't need vexatious behaviour as a prerequisite for a finding of unreasonable behaviour under Rule 13 of the Tribunal rules.
Well, that's also true under Willow Court, is it not?
Yes, but it appears the judge below erred on that basis. So there's, if one looks at page 225 of the authorities bundle, paragraph 36. What happened in Lee was a Mr. Gubbe basically made a very unreasonable service charge demand. He used wrong and sued on it. And the Court of Appeal concluded there were specific errors of analysis in the FTT's cost determination. First, there's a reference to Mr. Gubbe's belief. In this case, there's a reference to Miss Ward's tunnel vision. It says it was wrong to consider the question of reasonableness from Mr. Gubbe's subjective point of view. What mattered was whether it was objectively unreasonable Thus, the question of whether or not Mr. Gove was misguided was a potentially relevant consideration. If he thought he was acting reasonably, but an objective observer would say that he was totally misguided, and so that he was acting irrationally, that would indicate unreasonable conduct. And in this case, is a finding that the respondent's conduct litigation was incompetent. And this passage was relied on very heavily in the Upper Tribunal appeal. So if ground 1 or ground 2 is allowed, one gets back up to the 8 criticisms, which led to the First-Tier Tribunal having a number of bad things to say about the respondent's conduct litigation, but still, nevertheless, it hasn't answered the ultimate question. And so, hence, I said at the beginning, either in the event that the appeal were allowed on either ground, the appellant would be seeking that the Court of Appeal remake the decision itself, alternatively remit it.
Well, are we in any better position to remake it ourselves than the Upper Tribunal was?
I would submit yes, because this time round, the court does in fact have all of the information available. The supplemental bundle contains that. Judge Roger brought Hussain to the council's attention at roughly 4 p.m. the day before the hearing, and so it wasn't possible to bring lots more material to that. The parties had been approaching it on the assumption that it would be essentially the application of Willow Court and Lee and Ilfracombe rather than Hussain. Unless I can be of any further assistance, those are my submissions on ground 2, and that concludes the appellant's case.
Thank you very much. We will just rise briefly to see where we go from here. We won't be very long, so don't go anywhere.
rise if able.
Mr. Ham, we don't need to hear you on ground 1, but we would like to hear you on ground 2, please.
Well, on ground 2, we say that there is an interdependence with ground 1 because we adopt and pray and aid Judge Rogers' finding that it cannot be sensibly argued that the local authority's conduct of proceedings should be judged on a false view of what material was legally relevant to the question to be determined by the tribunal. The tribunal did not decide the time issue. The decision on costs only was under appeal. It found that using its discretion on those points that were raised before it, that a costs order was not appropriate. And in my paragraph 23, I've also referred to parts of Judge Rogers' decision which are consistent with the tribunal, the First-Tier Tribunal's findings, which further justify a discretion not being exercised in favour of a costs order. That's my paragraph 23, and I've actually sort of cut and pasted the relevant parts. He points to the fact that, and this is all based on the findings that the First-Tier Tribunal made, that the extent that works remedied some of the defects identified in the notice justified the service of the notice, or if they were different, then they could have formed the basis of an application to vary the notice. One of the key issues is that the process is very flexible. You can apply to vary. You can, if that's refused, you can appeal against the refusal. And there were discussions between the parties about variation both before and at the appeal hearing. And Judge Roger, we say, was right to focus on the fact that the appellant made no effort to seek variation or to persuade the local authority to vary the notice in accordance with what it said it was doing. It simply sat on its appeal and then used everything that had happened since the notice was served as a stick to beat the local authority with. Paragraph 53 of the judgment. The First-Tier Tribunal was entitled to form the view the notice was not nearly specific enough. Nevertheless, the only example it gave of that deficiency related to a single paragraph in the schedule of remedial action concerning the replacement of windows. The whole schedule contained 23 separate actions, and the work unrelated to the windows was required in plant rooms, substations, networks, and thus comprised more than 2/3 of the total. So even on the First-Tier Tribunal's findings, that yes, some aspects were not sufficiently particularised or were deficient, the majority was not. Again, that feeds into how unreasonable the conduct and whether a costs order should be made.
Are you inviting us? I mean, I put to Mr. Miller that Judge Roger had decided that the FTT's decision was flawed because they didn't answer the final question.
Yeah.
You don't, I think, dispute that.
No.
So you, just as Mr. Miller, are facing a position in which the costs or order of the FTT is flawed, and that Judge Roger then has three theoretical options. One is to set it aside and remit it. One is to set it aside and redo it himself, and one is to leave it in place despite the flaw.
Yes.
Now, are you inviting us to make a decision ourselves, or to remit it, or to adopt what Judge Roger did and uphold his decision not to set it aside?
Yes, it's the latter.
It's the latter.
We say that decision was right, because he could see that the whole process in the First-Tier Tribunal was flawed and had no regard to crucially legally important principle in Hussain.
Yes, but the point that Mr. Miller has taken in Grant 2 is that point, the Hussain point, was common ground tribunal below and was not challenged on appeal. Nobody appealed the substantive decision on that ground. And so it's wrong to approach the costs order from a different perspective. That's the point you're facing.
Well, yes, but although the parties proceeded on the basis that Hussain didn't exist, there was no decision made about that. And so that wasn't part of the decision of the tribunal that was then subject to appeal.
Well, it may not have been part of the decision so as to give rise to an issue estoppel or res judicata, but it doesn't detract from the force of the point that you have everybody, including the tribunal, proceeding on, let's say, a flawed assumption as to the state of the law. And then that isn't appealed, and the cost decision was on the back of it. Let me put this to you as a hypothetical. Suppose that everybody in the lower court operated upon a flawed assumption of the law, and then there is a subsequent decision of a higher court which says that decision was wrong. So Hussain has decided later rather than earlier.
Yeah.
You get that situation, which sometimes happens. But there's not been an appeal and nobody's applied to vary the appeal, and the costs application comes in. The judge dealing with the appeal says, well, if we had the benefit of the decision of the Supreme Court now, we know that everybody's proceeding on the wrong assumption. Is he then entitled, or she then entitled, to say, because we now know what the Supreme Court has told us what the law is, we can ignore the basis on which the costs order was made and look at it afresh? I'm not sure that's right as a matter of principle.
No, but I think I agree. But this is the other way around. This is a per curiam scenario where...
Why should it be any different?
Because of the timing. Hussain comes before. So Hussain applies before this appeal hearing takes place. And so I would say this court, for example, let's say it decided to go ahead and deal with the costs issue, cannot apply law that was wrong at the time of the First-Tier Tribunal hearing, legally irrelevant considerations, in order to determine the costs application. But that's the crux of it, really, and it's Judge Roger. I don't consider it can sensibly be argued that the conduct of proceedings by the local authority should be judged on a false view of the material which was legally relevant. Because this court would then be adopting an error of law.
Could the parties not agree between themselves that the appeal should be dealt with on a particular basis as to the date?
My learned friend says that he put to the witness, or rather his leader put to the witness, it's all should be decided now, but there was no agreement between the parties.
No, forgive me, I understand that.
Oh, sorry.
I'm just, on a chain of reasoning, I'm starting with the proposition, well, could the parties agree? Could the parties say to the tribunal, well, look, we strictly Hussain applies, but we agree between ourselves that it would be helpful to us if you decided it as of today's date, as we've got all the material here. It will save us having to deal with variations or revocation or whatever. We're all here. We'd like you to deal with it as of today's date. Could they do that?
No.
Why not?
Well, because it's inviting the court to make an error of law.
Tribunals, like most tribunals, has a strictly statutory jurisdiction. And maybe you can't stop the tribunal, give it a jurisdiction it doesn't have.
So that's your answer.
Well, my answer is that if we'd been in that position, it simply would have been a variation. And I invited the court to consider a variation because I got the law wrong. And I said, but hang on, we've all had a look. There's clearly a problem. We can refine the notice. We can take out of it all the bits that have been done in compliance with the notice, and we can rejig the bits that are wrong about the windows. That's how in practice it would have been dealt with. But we all assumed that we just didn't know anything about Hussein, even though Hussein had come out months before, and nobody was aware that we were all proceeding on the wrong basis. But if it had been the right basis, the solution would have been variation in my submission.
Can I be sure I'm clear what you're saying? You're saying that once Judge Roger in the Upper Tribunal had put everybody right and said, you all asked the wrong question, he's entitled to take that into account in deciding whether or not it's appropriate to have a further hearing on whether your conduct was unreasonable.
Yes,
Rule 13 purposes.
because he can look at all the findings, he can discount the findings that are wrong in law, which he can't apply those, and on the remainder he can say that doesn't change the FTT's decision on costs.
It's quite a strong thing to do for the Upper Tribunal to say the decision of the FTT was flawed because it didn't answer the ultimate question. I'm not in the position to decide it myself because I don't have the material, but I am in a position to decide it would be wrong to remit it. Normally if you haven't got the material to decide something, you'd send it back.
But the material he did not have was all material that went to the irrelevant question, which is all the stuff that had been done, or all the evidence about the works that had been done and so on and so forth. It was a narrow bundle.
Okay. And if the appellant is right on ground 2, what do you invite us to do? Decide it ourselves? Mr. Miller says we've got all the material, or send it back to the FTT?
I think you could decide it yourselves if you uphold ground 2, and I would then focus on, in the light of all of that, the discretion issue and the appropriateness of cost orders in such cases on the authorities.
Would that need a further hearing?
Yes, I think both parties would wish to amplify their submissions on that side of it. I have put some in my skeleton argument. I don't think my learned friend really addresses. You don't really address that in your skeleton particularly.
Not stages 2 and 3, no.
No. So I think it would have to be, if you upheld ground 2, we would require a further hearing.
Not just dealt with it on paper.
Well, I've made my submissions. I don't know if Mr. Miller has. I've really addressed the discretion issue in paragraphs 23 to 27. And I say that when one looks at that analysis, there's no reason to criticise the discretion below. And that if anything, this appeal is following down a line that has been discouraged.
And if there was going to be a further hearing, it seems to me a further hearing should be in the FTT.
Yes.
But there we are. Is there anything further you want to say on this? Thank you very much. Mr. Miller, do you want to reply on ground 2?
Yes, very briefly, my lord. My friend said that it would have been open to the appellant to have requested variation of the notice to include certain works, and then to appeal that request to vary if it had been refused. I've already addressed the court as to the conclusiveness in section 15.6, and I'd submit that's not actually, there's never a course of action available to the appellant. As for the broader question about how one explains the respondent's conduct, my submission is that if everybody is approaching the decision on basis A, that Hussein doesn't apply or people aren't aware of Hussein, it's no answer to say that the respondent didn't behave unreasonably because actually everybody was wrong and basis B was the correct basis. Hussein does not explain why the respondent didn't produce updated evidence. It could have been justification for why it didn't do that, but that wasn't the case that it ran. And in essence, if the appeal were not to be allowed on ground 2, one is essentially giving the response an indulgence by Judge Roger having found an authority that works in its favour. As I say, no submissions were made in writing on the basis that the respondent's conduct had been completely in keeping with the principles that ought to be applied in the FTT. I'd also resist the idea that the solution would have been variation anyway. So the First-Tier Tribunal decides that the specificity in the notice when it comes to windows is sorely lacking. I appreciate that Judge Roger says there might have been a different way to read it, but I would submit that that's another indication of where he's fallen into error. It's not open to him to say that the First-Tier Tribunal could have come up with another way of reading the notice when plainly, when one is looking at the cost decision, one has to look at the substantive decisions to whether it's reasonable for respondents to serve the notice that it did. And there are also other references. I don't seek to go through the First-Tier Tribunal's substantive decision in detail, but there's a finding, for example, that it multiplied the likelihood of an excess heat hazard by 500, which is completely unexplained. It decided that the absence of the hot materials hazards calculations meant that it's very hard to really find a starting point for the respondent to succeed on that issue. There are a number of other criticisms of the improvement notice in this case beyond the lack of updated evidence from the respondent. In my submission, and this is a submission I made in the Upper Tribunal itself, really Hussein would have had no bearing ultimately on whether this improvement notice would have been varied, set aside, or confirmed. But ultimately, Hussein doesn't provide any kind of answer as to why the respondent conducted its side of the appeal on the basis that it did. Those are my submissions, my lord.
Thank you very much. Thank you very much to both sides for your very helpful, succinct submissions today. We will reserve judgment. You will receive drafts in the usual way for you to comment on typographical errors, etc. Obviously, no re-argument. We'd also invite you to try and agree an order. To the extent you can't agree matters, then please written submissions which we'll deal with on paper. Please keep the draft confidential. You know the strictures about that. And then we will hand down our judgments remotely, no attendance required, and it will be published, sent to you and published on the National Archive. Thank you very much.
Well done.
Yeah, good to work with you, I think. No, obviously.
Well,
But you did a great job trying. That's for sure. That was a proper fight you put up.
that's an idea.
I thought so as well.
Yeah, definitely.
It wouldn't be much of a barrister if you rolled over at the first sign of opposition.
There are many who do.
There are
many who do.
There are many
They
who
quake
do.
in their boots.
Yeah.
This is a man of iron we're dealing with here.
Especially in the Court of Appeal.
Yeah, exactly.
I've been here 5 times led before.
Yeah.
It's hard work. I mean, I've seen them be a lot harsher.
Yeah.
I've had to, yeah.
Even on in the civil side of things.
Oh yes, yeah.
Yeah.
Because the criminal side are ruthless. If
Are
like
they?
it. Yeah. They don't even let you make your submissions. You say, I don't want to hear from you on the, you know, what about this? What about, you know, they go take you all over the place. Very unsettling. Yeah.
I used to go and listen to Lord Denning when I was training.
Oh, wow.
You
that
could
must
just
be
pop
great.
in and listen to him for half an hour or so, you know.
I would have loved that. Oh God! So we end up back in the FTT.
Practically living there these days, to be honest with you.
Well, it's all bread and butter, all grist to the mill.
Renters' Rights Act's going to massively increase the amount of business it has as well.
Yeah, I haven't had a really proper look at that yet, but yeah, I better
There's,
start studying.
There's more criminal offences for your sort of regulatory
Excellent.
side.
All grist to the mill.
Yeah, it's coming big time.
All right, well, I'll say goodbye, chaps, and leave it to you.
Nice to see you, Nick.
Maybe see
Take
you
care.
again.
All the best.
Cheers.
Richard,
We'll talk. There might be a tape somewhere.
I'll ask you outside.
Yeah, we'll do that side.
It's a rental.
Nearly done.
Thank you so much. I know, Abby, you got some, I don't know what type of lock you
My
got.
wig is still. I mean, I've had some chances to wear it, but you see how battle hardened his looks because he's a criminal practitioner. I feel like I need to beat mine up to look more senior.
Well, I think your wife would really have enjoyed watching that.
I'll see.
I can.
Right. Unless there's anything floating around big, but I think that's everything I found.
Would you mind? Oh, you're probably going to need your. You're going to need your bundle, aren't you? I was going to say if you could take it back to Chambers and we can collect it, but maybe hang on to it for a bit.
Oh yeah, no, I'll do that. Yeah, don't worry. I find that in my Court of Appeal bundle still.
Thanks, guys.
Right, we'll check this out. Thanks.
So how do you do that? How did you arrive and then they just finished it?
No, they want to end soon.
Because I don't think so. I don't think you understand when I told you. I'm like, today I think it's the worst mood I've ever been in.
And it's alright, but you're cooking early now.
That's true. That is true. Now I'm happy. But I'm telling you, yeah. I was in the worst mood ever. Like in my whole entire 18 years of this life, today was the worst.
No, there's no chance.
I promise you, I woke up ready to literally kill every single person in this building. I promise. You know, just one of them days you wake up and it's like the worst day of your life. I think, also I fell asleep so early, yeah? By 10:30 I was in my bed, fast asleep, snoring away. So I woke up still tired. I was thinking, no, this ain't right. Then I woke up and I wasn't going to come into work.
You came early, right?
Yeah, but I would, by the time I woke up, I would have been here for 8 o'clock. But then I was not feeling like to come in. And then I was thinking, do you know what, I'm just never going to come into work. Then I was going to call in, say I'm sick. And then it got to like 7:20. I was like, yeah, let me just actually be a bit grown and go into work. Then I forced myself to come here and I didn't eat any breakfast. And then I was just mad.
We need a meet and greet, yeah?
You can do that.
We
what, you? Why, what do you tell her that you can't do it?
I told her to give me the room. I wanna go that way. Actually, no, wait. Oh. I'm gonna go
Isn't it
upstairs.
normally just Ray's office?
Huh?
Don't you just take them to Ray's office?
That's what I'm thinking. I don't know if it's there today.
I ain't going to.
Yeah, she needs to reply to the emails. I got it. I'll see you upstairs.
Are you leaving your thing here?
I can't bother taking it upstairs. I'll get it tomorrow morning. whichever
I'll
call.
bring it up.
No, leave it. Whichever call I'm in tomorrow, just pop in the morning and take it.
It's fine, I can bring it up. I'm gonna bring my stuff up anyway.
Leave it. Leave it.
Great, kill me right now.
it dull. Because I thought Mr. Baldwin, no, I thought Mr. Baldwin did it really dull. Because far like his skeleton hand